Super, super. Thank you very much for making time to be with us tonight. So, ladies and gentlemen, as I said, this is going to be a very interactive session. We want to hear from you. So whatever questions you have concerning the practice and application of the labor laws of Ghana, please put them in the comment section, and our experts will be giving you authoritative responses to these questions. So before we start taking the questions from our guest, I want to take some opening remarks from our panelists. So let me start with Stephen. Stephen, let us have your opening remarks. Stephen, we can't hear you. Yeah,
okay,
please.
so good evening, everyone, and it's nice to be back here again. For those of us who are joining us for the first time, I'm sure you'll be wondering why I'm saying it's nice to be back again. We do this over a certain period, and I'd want to say a big thank you to the HR Certification Center and to my very big boss, Dr. Bassi, for always also availing himself. I know he runs a very tight schedule, but he's almost always around to help us to go into these discussions. And so I'm sure that just like the other sessions we've had, tonight we'll also have a very engaging session as well. Thank you, Governor.
Great. Thank you very much, Stephen. Dr. Bassett, we would like to have your opening remarks as well.
All right. Earlier on, I was unable to unmute myself. I don't know if it was coming from the hosts, but it's okay. I'm good now. All right. So good evening once again to all our participants, and thank you for joining. Right. So as my brother Stephen of the National Labour Commission had mentioned, we've done this time and again. And I pray and hope that the people we have online today are new persons. Otherwise, if some of them have been here before, what it means is that we'll be expecting that you ask new questions so we can all have a discourse around different perspectives or new areas of the Labour Act. And for that matter, the labor law generally. And as I always say, if indeed you are managing people, Ghana is not a banana republic. There are laws on the land. You cannot do things at your whims and caprices. You got to play by the laws. Even the policy you run with, if it is not analogous to the state laws, if they are contradictory to the state laws, to the extent of the contravention, that your policy will be void ab initio. And so we'll be sharing thoughts and experiences. I always say there's a lot of practice behind the letter of the law, the black and white statement put in the Labour Act. There's a lot of practice behind it. Probably that is why beyond reading the Labour Act, sessions of the sort are good, so we are able to share knowledge on the labor law. So I'm looking forward to we having a good discourse this evening to add a bit to the lot we already know.
Great. Thank you very much for that. And thank you for always availing yourself to be here with us. So quickly, let's go into the comment section. We want to find out, please do well to drop your questions inside the comment section. Any questions that you have concerning the practice of the Ghanaian labor laws, please do well to drop them in the comment section, and then we'll be responding to them. Right. So this is the first one. Can I retire an employee at age 57? If yes, what is the process? So any of our panelists can take it.
Governor, I think you make things difficult for us if you do not. Let me allow Stephen to respond to it. Stephen, you can
Sure.
take it.
Okay, so I think our participant wants to know if they can put somebody on pension at age 57. I think anytime from the age 55, a person can voluntarily go on pension. But at age 60, then our laws provide that one you must compulsorily go on retirement. And so the decision to go on voluntary retirement is one that you would find that in the most situation is necessitated by the employee himself. Unless there probably might be some intervening circumstances for which you would want to let somebody go 3 years into their compulsory retirement age. Then so you may have to be a little open with your question so that we know what it is that we are. Okay, so I think Kwabena, the person has corrected the question again. The person is asking if they can allow somebody to work after age 60.
Yes.
Unless
okay,
so yes, you can, but usually you would find that such persons are engaged on contractual basis, and these persons of that nature, you don't contribute net on their behalf. So yes, you are allowed to keep on somebody after the age of 60. There is nothing wrong with it, but you just engage the person on contractual basis. Like usually the question I ask is, what happened to our succession plan? And I'm sure that Doc would probably go into that arena. So if we have a pretty good succession plan, then I want to believe that somebody exiting at age 60 would have been given a chance to, mentor somebody or train somebody to take up in his stead when he finally goes. But all the same, I think on that score, I would allow Doc to speak to us on that. If yes, it's okay, but I'm just casting the net wide as to us taking a proper look at what our succession planning is going forward, so that we don't always have to keep the aged at work, and then we give the younger people the chance to also bring on board what they have learned over the years.
Great. So I think Doc to add something before we go to the next question.
Right. Before I add anything, lots of people are complaining that they are unable to join the session and that the class is full. What is that? And
yes,
we
so
all I can see 100 persons. Come again?
Yeah, so I'm trying to share to Facebook so that they can get access to there.
So you limited it to 100 persons here.
Yes.
Okay,
yeah,
that's fine. All right. So I think on the retirement bit, Stephen has actually spoken to it. The retirement age stipulated in our laws, you can look at the Pensions Act 766/2008. It's supposed to be 60. An employer cannot just voluntarily get up and say, I'm retiring you at an age. There's voluntary retirement if the employee decides to retire before 60. Otherwise, you may only do so on health grounds or any other good grounds. On the bit of succession planning, Uncle Steve and everyone else, it's surprising. Now, just today, Thursday, 2 major multinationals, one in the telco industry, the other in the mining sector, contacted me today, 2 of them, that they want director HR. So one of them have their head of HR leaving. The other, I know the head of HR had some health issues, for which reason she needed to retire before the age of 60. And the question I will ask you, so all this while, these 2 major, I'm not talking about roadside organizations, so I'm talking about organizations that have staff base of 5,000, 4,000 employees. HR department alone has over 20 persons in there. How come they have not been succession planning put in place? Yes, I do know that some of the multinationals deliberately by policy would not promote people beyond a certain level. By their policy, they believe in poaching or bringing persons from outside to occupy certain roles. But beyond these policies, it does look like even the large firms are not taking the exercise of succession planning very well. In the year 2021, I got contracted by Bank of Ghana through Apex Bank to run a talent management succession planning for nearly all the rural banks across the country. Quite a number of them, 240. So what Apex Bank did was to organize them on zonal basis. So we did from the northern sector to Kumasi, all of them gathered in Kumasi. We did Volta, Eastern, Greater Accra in Kufredia, and then Central region, Western region, and the likes all gathered in Takoradi. And you realize that some of the time, the CEO will be due for retirement. And to head a bank, retirement is not always at age 60. If you know Bank of Ghana directive, you cannot be a chief executive officer for a bank, not even the rural banks, beyond a certain number of years. 10 years most of the time for the universal banks, and 12 years for the rural banks. And all this while, what has been done, or what do we put in place to ensure effective succession planning? And so I only want to speak to the succession plan bit. It does look like many organizations don't seem to be taking this very seriously. As for the bit of retiring people before 60, ordinarily the answer is no. It does not lie it's not within your prerogative to decide when people are retired. People retire. The law has taken care of that. The person will take the initiative to voluntarily retire, or you must have good grounds, and mostly it's in areas of health, to retire people before the age of 60. Otherwise, the employer cannot take a unilateral decision to retire you before 60.
All right. I hope the person who asked the question, you have got a satisfactory answer. Okay, so let's okay, so before I take the next question, we are having some difficulties getting more people in, but we are working on it, and I'm sure in the next 5 minutes or so it will be corrected. Okay, so Paul is asking a tip on dismissal, please. Paul, what do you mean by a tip on dismissal? Can you please be a bit more specific with it? Please be a bit more specific. So can I allow someone to work 60? I mean, okay, we have answered that. Okay, so Stephen, this one is to you. How long should someone act in a role before they are confirmed? How long should someone act in a role before they are confirmed?
Okay, thank you, Pabna. Well, as for acting positions, it depends. You know, in the public service, when you act for a defined period of 6 months or more, then it is considered that the idea is that once you act beyond that period, then you should be considered for the position in terms of being actively appointed for that role that you have been acting in. However, it is not always the case. It is not automatic that once you act, you must be appointed for that position. I think that we have to make that clear. Now, I use the public service as an example because you may find that the minimum requirements might differ in the private sector. Now, if it is in the private sector, then the question would be, what does the policy say? So if our policy allows that when a person should act in a role for, let's say, 3 months or 6 months or for 1 year before they can be confirmed for that role, then we let our policy work for us. But if we do not have a policy, then I think that it's about time we begin to look at what our establishment allows us to do and not to do, and then design something around it, because every day is a learning experience. And so if it is that at the present moment, somebody is acting in a role, but you, Araba, at this point that you can't tell if the person should be confirmed for that role or not, then the question I would want to ask is, how long has the person been in that role? And if you look at the numbers that the person is pulling whilst occupying that role, do you think that the person has done satisfactorily enough to be able to for you to appoint him into that role? But like I said, if our policy says 3 months or 6 months or 1 year, let's work with that. If we do not have one, then I'm sure that following today, we are all coming to learn that we can design a policy for acting roles and then have defined timelines that should go with them. Thank you, Kwabena.
Okay, thank you. I hope your question has been answered, Araba. Okay, so Sherry is asking, should lunch hour be excluded when marking or computing overtime hours on weekends, where weekends are not official working days? I'll go to Stephen again. Stephen, did you get the question?
Yes, Kwabena, I got it.
Okay, all right.
The person wants to know, Sherry wants to know if the lunch period should be considered as when, or it should be excluded when we are calculating overtime, especially when it's for weekend work.
Yes.
Now, we all know that in every given situation, an employee is supposed to work for 8 hours in a given day. Within that same time, you have break periods. Now, once the person has come to work, the break period is ideally the time off work. So if you're calculating overtime, the time that the employee is resting will not be a part of the hours that we are going to calculate, the active hours. So we call it the active hours. So let's say it's Saturday work or Sunday work. They are doing, I don't know, maybe like 10 to 3, but between 12 and 1 is break. So the active hours will be 10 to 12 and then 1 to 3 p.m. So if you're calculating the overtime, that's where you have to look at. Yes, they have been at work for all of the period, but we're looking at how long they have been actively involved in carrying out the work. And so you would find that the break periods or the lunch hour is taken out of the number of hours that the employee has spent in doing active work. And that, because the whole idea is to reward for work done. Now, the break time is the employee's own time, even though they are at work, to take it easy, drink some water, eat some meal, refresh themselves and then get back on the job again. So you would find that in making these computations, we exclude that 1 hour of break in calculating for overtime. And this is in respect of overtime only, because if it relates to salary, usually it is consolidated. So you find that all of these are factored in before a particular salary is attached to a defined role. Thank you, Kwabena.
Okay, thank you. Thank you very much, Stephen. Sherry, I hope your question has been answered. Iris says, in writing an appointment letter to a new employee, the officer mistakenly quotes 6,000 as gross, but figure should be actually 4,000. What can be done about it? The mistake was seen after first payment when he showed his appointment letter as a proof. What are the remedies for the company and the new employee as well? So I think I'll shoot this to Dr. Bassi.
That's quite an interesting one. Now, Kwabena, we all know that in law, there's a difference between truth and facts. The truth might be that the company intended paying 4,000, but the fact is the appointment letter stated 6,000. It would be pretty difficult for the employer to defend himself. I mean, the best way to test whether as an HR you are doing the right thing or not is to assume your conduct being tested at law. I mean, it's only when we test the efficacy of the law that we tell whether it's a good practice or not. Trust me, if this should appear before a labor court judge, it will be difficult for the employer to defend himself. You have stated 6,000. You went ahead and effected the first payment of 6,000. It will be pretty difficult. The only thing I can advise is for you to call the employee, have a conversation with the employee. If the employee so understands that, yes, I do admit that this was a mistake and therefore let us correct it, and I'm willing to take the 4,000, so be it. Otherwise, if the employee takes an entrenched position, it is 6,000. 6,000 is what my appointment letter says or contract says, and you had gone ahead to pay me so, and so that is what we agreed on. The rule of the game is evidence. In the absence of evidence, there will be no case. And so the evidence the employee has is the fact that you mentioned 6,000. That's the fact. That's what the judge is going to work with. The truth, which the judge may not be privy to, would be that it is 4,000 we thought we were going to pay you. And so this is quite a Herculean, it's quite difficult. I don't know what other evidence the employer is able to prove. Maybe during the verbal contractual movement, during the interview and all of that, the offer and acceptance, maybe the session was recorded. Otherwise, in the absence of any evidence, as I sit here, it is 6,000 the gentleman ought to be paid, and it will be extremely difficult for the employer to argue otherwise and to convince any adjudicative house, be it the traditional court or a quasi-judicial body as the National Labor Commission. It will be pretty difficult. The only thing you can rely on, in my view, is call the employee, sit down with him, and then have a conversation. If you engage the employee and the employee understands, so be it. And I will encourage the employee to also take it easy, especially if you know in your heart it is 4,000. Otherwise, if you insist on the 6,000, an employer can find ways and means of removing you from the workplace. I'm not sure Stephen would like the statement I'm about to make as a member of the National Labor Commission.
Please, I'm not here.
The punishment for unfair termination is not deterrent enough in this country, in our labor regulation. And so it is very easy for an employer to remove you, to terminate you. Even the cost of litigating or taking the employer on can be quite expensive and time-consuming. And so it is much easier for employers to terminate appointment of employees, even if it turns out to be unfair termination. The remedies are not too heavy on the employer. And so bearing this in mind, the employee, if you know in your heart it is 4,000, only for you to receive a letter and see 6,000, you might want to reason just to secure your employment. Otherwise, if the employer does know the law well, sometimes we say that if you know the law so well, you want to break it with confidence because you're aware of the consequences of breaking that law. And if you can meet up with the consequences, there we go. Because really, employment relationship is not a relationship of servitude, it's a relationship of service. And so traditionally, the courts, the National Labor Commission, doesn't compel you to employ or to work with a person you don't wish to work with, especially if you are a private employer. There are only in rare cases where the court or the Labor Commission will order reinstatement if it is if the employer is the states or the government. If it's a private employer, at the end of the day, if the termination is declared unfair, the employer is made to pay compensation to you, but is hardly compelled to re-engage you if he really doesn't want to work with you. So that is what I can say on both sides, on the part of the employer, on the part of the employee.
Okay, thank you. Thank you very much, Dr. Bassi. Let's check for, okay. I have a lot of questions here. Okay. Okay. I think we have answered this question time and again, but I'll ask it anyway. From Judith, please, what is the maximum period an excuse duty can be granted by a medical practitioner? Stephen.
Okay, so let me answer it this way. Unfortunately, there isn't a maximum period that a person can recuperate from an ailment. Now, with that as the foundation, it would also come to the fact that you cannot necessarily say that for malaria or for a backache or for a broken arm or a broken leg, it should take somebody 2 weeks to recover, or it will take another person 3 months to recover. Usually, these things boils down to what the policy says when it comes to ill health. So that you find that in some policies, if it is that the recuperation is going to take a longer period, there are certain steps that are put in place to ensure that both you and your employer, your relationship is dealt with fairly. So I have seen certain conditions of service where you find that, let's say an ailment will take you, one that I saw, they had it for a period of 1.5 years. So in your first 6 months of recuperating, you get your full salary. And then in the ensuing 6 months, you get half salary. Then in the third 6-month period, you get, it is reduced to 35% of your salary. Now, at the end, before the last 6 months would expire, what the employer would do is that they would write to SNIT to put together a medical board, because at that point they want to be sure if you are fit enough to return to work or not. So that if the medical board says you are unfit to return to work, then they can let you go on medical grounds, which is one of the grounds under Section 15 of our Labor Act, that you can be let go on medical grounds. So that is there, and this is the situation where we are guided by policy. Now, if we are not guided by policy, then that is where the problem really is. And so most of the time, Dr. Bassi will tell you that put it together on paper. Put it together on paper. Now, there's a reason why Dr. Bassi will always say put it together on paper, because if you don't have it on paper, then you now have to deal with it on person-to-person basis. And if you are not careful, you might be delving into the arena of either discrimination or inequality, because you might do 3 months for Kwesi, but when it comes to AMA, you might not be willing to do 3 months. You might want to do less, and it will create a situation for you. So yes, like I said with the foundation statement, there is no exact period that a person's body can recuperate. Now, it is the medical officer attending to the said worker who can determine. So if they keep the excuse duties coming, yes, there's nothing we can do about it. But if we are doubtful of the nature of the ailment and the periods that the employee is being asked to stay away from work, nothing stops the employer from seeking a second opinion. Now, if you're going to seek a second opinion, then you should know that that's cost that you are supposed to bear as an employer. You cannot tell the employee that we want to seek a second opinion. However, that opinion will be borne out of your pocket. No, it doesn't work that way. So if we are not comfortable with the number of excuse duties that is being presented to us, and we want to seek a second opinion, we are allowed under our laws to seek a second opinion, but any expense accompanying that would be borne by the employer. Thank you, Kwabena.
Okay, thank you very much. Let's take the next question. Okay, so Irene is asking, an employee who has been put on interdiction pending the outcome of an investigation proceeding pending the outcome of an investigation proceeding resigns even before the investigation ends, probably because he or she is guilty and will be dismissed. Per the condition of service, an employee is entitled to full benefits if he or she Oh, I'm missing this. Okay. If an employee is entitled to full benefit if he or she resigns given due notice, a person who is dismissed forgoes any end of service benefits. For such a person who is eventually found guilty, how do we go about this within the law? Dr. Bassi.
All right. I'll share thoughts on that. But quickly before I do that, the earlier question that Stephen helped us to respond to, I just wish to share a thought or two. I've advised several organizations on how to go about this excessive number of sick excuse duty and stuff like that. So you see, Stephen rightfully mentioned that there is nothing stated in the law, and really, nobody brings sickness upon himself, and we cannot determine how long recuperation will take. Your body might be different from mine. But you see, again, law is founded on reasonability. It is not for nothing that the law would, while stating the grounds for termination in section number 15 of the Labor Acts, will also include sickness. Ideally, the example Stephen gave, yes, it's a good one existing in a company, but trust me, that's an overkill. That is an overly benevolent employer. For you to be sick for 6 months, you are having your full pay. The second 6 months, that is 1 year, and we give you half pay. 99 of 100 employers would not do that, and they'll be right in the law. It is okay for an employer to be overly benevolent on humanitarian grounds. Now, if the standard thing I have seen in many companies, I've been through quite a number of organizations, at least 170 companies, and advising them on things of the sort. If you are sick for 3 months, and you are not recovering, we give you full pay. The second 3 months, we give you half pay. 6 months, you are not recovered. The employer can remove you. Read section 15 of the Labor Act. I employed you to perform a job. Your health is not allowing you to get a job done. We cannot hold the employer's assignment or the employer's operation to a ransom in the name of you are sick. Now, some of the sickness actually, and I'm not saying, I'm human too, I fall sick also. So I'm not talking about falling sick 2 weeks, but for 6 months, you are not available to do the work. An employer can remove you. But like he said again, for you to have an easy way around these things, document them, put them in policy so that they become very easy for you. Now, one of the very difficult areas is when the excuse duty or the sickness is not consecutive. So the guy is sick for 3 days in a week. He comes to work 2 days in the week. The following week, he's sick all through the week. The week following, he's fit to come to work. So it is intermittent. And so you're unable to count the continuous period a person is off. Even that one, standard practice, the practice behind the law is you medically board the person. And if the person is declared by medical professionals to be unfit to work, you are free to remove the person from your workplace on health grounds. But the caution is you don't take that decision unilaterally as an HR. Oh, from the way I see you and the way you've been falling sick, I don't think you are fit to do the work. No, as an HR, you are not a medical practitioner. You are not a medical expert. You must board the person medically for the doctor to declare that the person is unfit to do the work. But to wait for 1 year, 1.5 years, that will be stretching the issue. That will be an overkill. And I don't think employers are actually bound by law to do it that way, except that if you do it, you see, the law always gives us minimum standard. If you go beyond the minimum standard as an employer, we will clap for you, but you don't go below the standard. All right, now to just to my contribution to the practice of excuse duty, overstretching, and the sick leave issues and blah, blah, blah. My substantive question, which have to do with an employee have been cited for a wrongdoing, interdicted, and before the disciplinary hearing, The employee comes that I am resigning. That is playing smart. That is playing smart. And as an employer, now, employers do not have the right to refuse resignation. Resignation is determinable at will. The moment the employee says, I am resigning, the only thing he has to fulfill is notice requirements. That is stated in section 19. We have to interpret section 17 and 19 together. It's always in tandem, all right? Now, so when notice requirement is fulfilled, or the employee is willing to pay in lieu of notice, that employee can go. But the caveat, the exception to that right to resign at any time is when you are undergoing disciplinary action. The moment the employee is undergoing discipline, he doesn't have the liberty to resign at any time. Well, you may resign and suit yourself, but we'll go ahead and hear the case in absentia. We all know that when an employee commits an offense, the law says take the employee through the disciplinary process. The disciplinary process may require that we interdict you. Interdiction is stated in section 8 of the supporting legislation, LI 1833, that we can interdict you for 6 months. Interdiction is more like an advance suspension for you to give way for investigation, or that your continuous stay in the office may further destroy whatever for the organization. So those are the two reasons for which we interdict. Now, you can interdict, you can merely query, and when you receive the employee's response to the query, you invite the employee to disciplinary hearing. Now, there are two rules of natural justice that govern employee discipline, as we all know. They are normally expressed by the lawyers in Latin terms. The first one is the audi autorem pattern. Audi autorem pattern, which means that you must always hear the other side, let me say so, because of what the Constitution of Ghana admonishes, which is presumption of innocence, that a person suspected of an offense is presumed innocent until proven guilty. I know the reverse is what we do around here. The person is already presumed guilty until proven innocent. That is not what the law says. The law says, consider him innocent until you prove him guilty. Now, one way to prove the person guilty is to hear the person. Guess what? That you must be heard is not an obligation to the employer. The employer may give you, or not may, shall give you the opportunity to be heard. It doesn't mean you must be heard at all costs. So we give you the opportunity to be heard. If you fail to take the opportunity, we invite you to hear it. You fail to appear, we can go ahead and determine the case in your absence, all right? There are only two types of cases that at all costs you must be heard: murder cases and cases of divorce. At all costs, we have to hear from the culprits. Otherwise, audi autorem pattern, which means hear the other side, will give you the room to be heard. If you refuse to avail yourself, we can determine the case. Now, the second rule of natural justice is the nemo jude in causa sua, that a man cannot be a judge in his own cause. But I'm dwelling on the first one. So if we have put you on interdiction, pending investigation and subsequent disciplinary hearing, and you say you have resigned, well, you can go. On our records, you did not resign. We'll go ahead, determine the case if you do not appear to defend yourself. And it's almost as if once you are not there to mount your defense, you are most likely going to be guilty. If the offense is a dismissible offense, even though you claim you have resigned and you are gone, on our records, you have been dismissed. Once we finished and determined the case that is a dismissible offense, we will go ahead and dismiss you, put it on our records. And if any company so calls on us, any government agency calls on us to know about you, the report we are giving is that you were dismissed on our books. And as far as we all know, once you are dismissed, you lose every single benefit. So every condition that applies to dismissal applies to you. Many employees like to outsmart the employer using this, but I can tell you on authority that cases have been determined by the courts that once you are on disciplinary you have been called for disciplinary action, you lose the right to resign. You cannot truncate the process and go away. Most recent one I will share. I was at the National Labor Commission last week, Thursday, on behalf of Casapreco. And I told myself, Stephen, please, last week, Thursday is the last time I came to the Labor Commission. I won't come to the Labor I've stopped doing labor cases.
Praise the Lord.
Too much time involving and all of that. But last Thursday, I was there to represent, Casapreco. Now, company after company have had this challenge I'm sharing with you. The last one I handled is for one of the banks where this gentleman had reduced his age. So on the books of the employer, he's 57 years old. They filed his SNIT, and SNIT said, on our record, the guy is 60. And at age 60, beyond 60, you don't contribute, you become a beneficiary. Then the organization came back, did their homework, and realized that the guy had lied about his age. As soon as he was written to appear before a disciplinary committee, he quickly brought a resignation letter. And the HR director called me and said, forget about that guy. You don't recognize any resignation. Deny him all his benefits, call him for disciplinary hearing. If he refuses to come, go ahead, determine the case, and dismiss him formally and put it on your records. Well, I don't know, maybe a lawyer had advised him. He later came back that he was rescinding the decision to resign and that he was now willing to go through a disciplinary process. Right at the entrance of the disciplinary room, I am told, he fell on his knees and crawled from the entrance to where the board was sitting, asking for forgiveness and all of that. The HR director stepped out of the room, he excused them and called me of his action. Then I accordingly advised, I'm a consultant to that bank, so I advised that, all right, you can go ahead and determine the case and put on record that he has been dismissed. However, you still have the power as management to pardon him, considering his age, he has started, so pardon him and give him his benefit. But it is important you go through the process with him, otherwise you are setting a bad precedent for all other employees to be using that route. So you don't just dismiss the case or forgive him. Go through the case, dismiss him, or tell him his offense is dismissible. However, as a management, we want to pardon you and we want to forgive you and allow you to retire in peace. And so my answer is, if an employee is up for discipline, you can refuse his resignation. You can't hold him down, you can't tie him. If he says he wants to go, allow him to go. Go ahead, do the case, determine it, and issue the appropriate punishment, even in the absence of the employee. If the employee so refuses, he can contest it at the law court. And the first thing the law court will do is to ask of the processes of disciplining the employee. You gave him opportunity to be heard, audi alteram patent. He didn't take the opportunity to be heard. You go ahead and determine the case, and most likely you'll be on the right side of the law.
Great. Thank you very much, Dr. Bassett. That was a very elaborate one. But before we go on to the next question, we'll quickly want to take a message from our sponsors, the HR Certification Center. So kindly stay tuned in. We'll be back shortly. Thank you.
Percent of the world's leading multinational companies. Why do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.
Right. Thank you very much, and thank you for staying tuned in. Okay, so let's see what more questions we have. So Irene has been answered. Okay, Kay is asking, is it possible for a person to be given 2 roles, say HR and PA, and receive double salary? Stephen, kindly take this for us.
Okay. HRMP. Yes, that's some wild combination, because if you have to deal with the concerns of everybody at work plus other HR related matters, and you now have to also double as the personal assistant to whoever. In as much as it is possible, it is not something that from where I sit I would advise. Now, I am sure that we can find some equally competent person to occupy one of the roles so that you can devote time and attention to just the role that you're supposed to do. Let's not always think about the fact that because you're performing both roles, then yes, you should be paid double salary. No, it doesn't work that way. You might be given some additional role, but it doesn't always necessarily commute into being paid double. You may receive some enhancement, something of a motivation factor to what you are normally supposed to draw as salary. But for an employer to give you 2 distinct roles and pay you double for those performing those roles, it's not something that is possible. And like I said, from where I sit, it's not something that I would even advise you if it is something you're considering on taking on. It's not something I'd advise you, because if you're failing in one, the possibility that you would be cleared off the 2 is high than this being let go of one and keeping the other role. So let's be minded, in as much as it is possible. Yes, theoretically it is possible, but practically the nuances of the 2 roles would give you cause to not perform so well at both roles, no matter how effective you can be. I don't know. The HR job is a tough one. It requires you thinking on your feet on the go all the time. So to now, the time we need you as HR, you are doubling as a PA. The time we need you as PA, you are doubling as HR. It becomes conflicting, and it's not something I'd advise any person to find themselves in. Kwabena.
Okay, thank you very much, Stephen. So let's go to the next question. Okay, what is the right step-by-step disciplinary process, and who should be part of the disciplinary investigation committees? Am I getting this right? So what's the right step-by-step disciplinary process, and who should be part of the disciplinary investigative committees? Dr. Bassett, would you want to take this one?
Yeah.
Okay.
As for the full disciplinary step, the process step by step, the person who asked the question, you need to enroll for a labor relation program, a labor relation course. I mean, I teach disciplinary process 2 days, 2 full days, 9 a.m. to 3 p.m., 9 a.m. to 3 p.m. I don't know how I'm able to take you through the disciplinary process in about 2 or 3 minutes opportunity I have to answer you. It's quite technical. There are a lot of legal considerations. The disciplinary committee is a mini court. It's a court now recognized by the Constitution of Ghana, so much so that your work that have been done as a disciplinary committee is recognized by the traditional courts, except that because we run the appellate system in Ghana, the disciplinary committee is a lesser court relative to the traditional court, so much so that if there are fundamental legal blunders in your disciplinary process, the traditional court will overturn your decision and nullify the processes. And so it's a full-fledged program. I mean, we've done it for the likes of the Ghana Ports and Harbors authorities, the Casa Precons, the MTNs, and the rest. And it's a 2 full-day workshop for you to understand the disciplinary process. But if you ask me who can sit on the disciplinary process, remember the second rule of natural justice, nemo jude in causa sua. You cannot be the person who accuses an employee of an offense. You are part of the investigative committee. Then you sit on the disciplinary hearing board or committee, and then you sanctioned the employee. Once you play once you play 2 of these 4 rules, the whole exercise, like we used to say in secondary school, is cost 90. You can only do 1 of the 2. Even in the traditional court, you cannot be an accuser, a prosecutor, an executioner, an investigator in the same case. My advice, if you are asking this question in your capacity as an HR, don't be a part of any of these committees. Convene the committee, put the committee together, give them their guidelines, but don't sit on the committee yourself. The moment you are part of the investigative committee as an HR, you have lost every right to be part of the disciplinary hearing committee. The moment you are part of the disciplinary hearing committee, you cannot be the one to sign off the termination letter. So you can only do 1 at a time. And my advice is, don't be a part of the process, guide the process, put the committee together. Because of matters of conflict of interest, you may want to excuse the employee's direct boss, may not sit on the committee. His judgment can be compromised on the committee. So there are a few technicalities, but nearly everybody or anybody can sit on a committee, except some of these red flags that I'm raising on who qualifies to sit on the committee. If the person going to be terminated or to be punished is a very senior person, and probably HR may not have the locus to be the one to sign off the termination or the dismissal letter, then maybe HR may be part of the hearing, because you know that the termination will be signed off by the chief executive officer. So this is what I have to share. But trust me, the business of employee discipline, taking them through the process, is quite technical, and you need to have a training to have the confidence to go through carefully. Now, let me just quickly remind you, or those of you who have heard about this case before I sign off, the case of Stephen Poggi and Stephen Poggi versus Stanbic Bank, where the committee compromised or sidestep the disciplinary process. Though Stephen Poggi had committed an offense, which was conflict of interest, the Supreme Court nullified everything Stanbic Bank had done. And the Supreme Court mentioned these bodies. Which bodies is the Supreme Court referring to? Disciplinary hearing body, who, however, have the power to determine a person's livelihood. If you take a job from a man, if you terminate a man, you are taking food out of his mouth. So he said these bodies who, however, have the power to determine people's livelihood must avert their minds to the rules of natural justice when they are disciplining employees, and anything to the contrary will be void. Stephen Poggi committed an offense, but on technical grounds that the company sidestepped processes of discipline, the Supreme Court quashed the termination, ordered a reinstatement, and ordered compensation to be paid to Stephen Poggi for committing an offense. But because HR does not understand the technical processes of discipline, they lost the case neatly at the Supreme Court when the case rose from the National Labor Commission through the Court of Appeals and landed at the Supreme Court. The Supreme Court quashed every work they have done because the processes of discipline were not adhered to. It's quite technical. You need to be trained in how to do employee discipline.
Right. Thank you very much, Dr. Bassi. Okay. So this is coming from Comfort. She says, please, I'm an HR in a sachet water manufacturing company. My question is on this break system. I'm finding it difficult to institute a break system because we do daily targets. The employees themselves do not want to go on break because they say they are in a hurry to go home. They will use the rest of the time to complete their daily targets instead. What can I do? Let me put it to Stephen.
Okay. So, Comfort, your work is hard, forgive me, but they don't want to go on break. Okay, so Comfort wants to know how she can go about putting in a break system. I know that I have been to a few number of water producing companies, and those guys still go on break. In as much as there are set targets, the break periods are also well respected. So this is what they do. Then I'm just sharing with you what I have seen other places do. Maybe you can use that as a guide. So there's one such company close to where our office is. I just pay them a normal visit. Now, in as much as they also have these daily targets that they are supposed to meet, what they have done is that they have set up their machines in such a way that when it is break time, they shut down the treatment plant. So you know the system where they produce the sachet, it comes into another arena where the water is filled. They produce the sachet all right, but it doesn't come into the part where the water is filled into the sachet, so that at that period, everybody within the filling part of the factory goes on break. So the guys at the sachet making part will continue to do the printing all right. When these guys return, they put on the machine. Whilst they are filling the sachet, because these guys have already printed the sachet in excess or in advance, then they can also go on their break as well. So you realize that one part goes, the other part stays, the other part returns, the other part goes. It's one way that you can instill the break system, because, and again, if in a given day, you're supposed to do, let's say, 1,000 bags per day, I'm sure that you can set out the production timelines in a way that we can capture maybe our first 500 between when we put on the machine and when it is an official break time. And then we split and do the rest after the official break time. It's one way that you can get everybody to get break, because you see, you have machines in there. Now, if the people are not getting breaks, over time, they will begin to get, there's a term we use, I've forgotten, but they begin to get inattentive to what they are doing. Now, the moment that comes in, the likelihood that somebody would injure himself is high. Now,
Stephen, was the term
injury
fatigue?
at the work, thank you. You become fatigued. Thank you, Kwabna. Kwabna, you are learning power. So so you would find that fatigue would lead a person to do a lot of things. Besides not counting the sachet well, they can get involved in an accident at the workplace, either with the machine or with another colleague worker. And that is cost to the company. So like I said, maybe you should look at having this scheme that I just described to you. Try and see if that will also work at your place. Otherwise, over time, it's cost that is going to come to the company. And I'm not sure that that will help you as HR. But at least this is the least advice I can give you.
Thank you very much, Stephen. So, ladies and gentlemen, these are the kind of lessons you'll be getting when you enroll with the HR Certification Center for the Professional and Human Resources, International Professional Human Resources Certifications. Stephen, as well as Dr. Bassi, are our facilitators. And to all the HR practitioners and business leaders here, these are things that you need to get your hands around. And in recent time that people are becoming more sophisticated because of AI tools, technology, and innovation. As an HR practitioner, a business leader, you need to understand the kind of business that you are operating in, and need to be able to help you to properly manage people and the systems. So I'm calling to you, join the International Professional and Human Resources Certification Programs. It's a 6-month certification program. We are going to take you through the labor relations. We're going to take you through the labor laws, strategic HR management, HR planning, HR employment, HR development. And these things are going to make you an HR practitioner of your sort. So if you want to be part of this, we are actually setting off for our 37th cohort on the 2nd of December. So keep some of the money that you are planning to use for Christmas. Investing in yourself too is going to tell a lot on your professional growth and development. So call this number 0244 122 855. You can call or send a WhatsApp message, and our facilitator is going to give you all the information that you need to help you enroll for our incoming cohort. And do well to follow us as well on our various social media channels. We are on Facebook, we are on Instagram, we are on LinkedIn, we are on TikTok, and we are on X as HR Certification Center. Please note that the spelling of center is CENTRE. So follow us, and we are going to we provide, or we give out a lot of content that is essential for your professional development. And you can also sign up for our newsletters that we share bi-weekly to give you information on HR trends and everything that you need to help you become a better HR practitioner. I can see Stephen is answering some of the questions in the chat box. Thank you very much, Stephen, for doing that. Let me take this one from Richard. Richard is asking, when an employee is not scheduled to work on a statutory holiday, is the employee entitled to holiday overtime, i.e., the employee's rest days fall on the holiday and he works on other 5 days? Dr. Bassey, can you take this for us?
I wish Stephen could speak to this one, please.
Okay.
I know he's well versed in overtime and holiday work and all of that. I think he will have a better response than myself.
Super. Okay, so Stephen, over to you.
Okay, Doc. Thank you. Doc just gave me a 2 pass. Let me see if I can score a nice goal from it. So Richard wants to know if a person is not scheduled to work on a statutory holiday, if the said person is entitled to holiday overtime. If you are not working on the said day, then you don't qualify to be paid overtime. So Richard, let's say myself, you have scheduled me to come and work I'm supposed to come and work, but there's a public holiday for which we don't come to work at all. Then it would mean that I will not qualify to be paid overtime. However, if on the said statutory holiday, you need me to come and work, then it is only fair and proper that you reward me for the number of hours I am going to spend at the workplace during a statutory holiday. And so you would find that the rates for holiday work and weekend work, you would find that those rates are higher than weekday work. That's how it's done. So if my rest day falls on the holiday, let's not forget that my rest day is my rest day. That it has fallen on a public holiday doesn't mean that I do not enjoy the rest day anymore. If anything at all, it is +1 because that holiday is going to be enjoyed by people who are not also on their rest day because it's a statutory holiday. So everybody is at home. So we all will enjoy it. And so you find that most of the time, measures are put in place to make sure that if my rest day falls on a public holiday, another day is given to me to enjoy my original rest period. Now, like I said, if I am to come and work during the holiday, I qualify to be paid overtime for that period. If I do not come, I don't qualify to be paid. Now, if my rest day falls on a public holiday, what it means is that it is +1 for me for that particular rest period. So what it does is that when the holiday comes on, automatically my rest day takes a back seat. And then after the holiday, my rest day will come. So ideally, I'll get to enjoy +1 extra day because it was supposed to be originally my rest day, but that said day has also been a public holiday. So I get to rest twice. It's normal. It's allowed under the law. Kwabena.
Right. Thank you very much, Stephen. Okay. No, I'll not take this question. It's too political. Okay, let me see this one. This one is coming from Selassie. Wow, Selassie, this is very long. It's like thesis. Oh, all right, let's attempt it. So Selassie is asking, we have new employees from the mining sector. Earlier, the client advised we sign 1-year contract with them. Intermittently, the client had issues with rate breaking. Okay, the client had issues with rate breaking down, and we had to lay some of the staff off. I engaged the client on a redundancy package, and they argued it's a fixed term contract. Thus, redundancy was not to apply. I explained it is redundancy because the fixed term contract is for a year, and since it is not due expiry and we've had to lay the staff off, we are rendering them redundant. Consequently, the client requested consequently the client requested to sign a project-based contract with the staff going forward. And their explanation for project-based is that if they give me a project period for a month and I sign a month contract with the staff, when the project ends in a week's time, the staff's employment contract should automatically terminate. Please, what's a legally appropriate way to phrase contract terms for these staffs? Kindly note, the staff are very entitled and difficult with community backing. Dr. Bassey, should I throw this to you?
This is not a question we should be answering on a medium of the sort. The person who asked the question, respectfully, you must consult, because I imagine there will be too many hidden facts. Now, in law, the slightest hidden fact can shift the goalposts. So we might be ill-advising you, especially when we haven't read the contract. I don't know if Steve shares my opinion, but to sit on a platform of the sort and say, go and do this, go and do that, no. You would want to consult, let us understand the issues, read the contract so we can advise, because a contract between an employer and an employee is one of the major bases for adjudication by the court. Beyond what the Labor Act and state regulations says, a contractual agreement is respected. And I can tell you that the contract is way, way beyond the summary you try to give us over here. And it will be difficult for me to want to advise you when I'm not privy to all the facts surrounding the contract. I might end up misleading you. I don't know if my colleague have any dissenting opinion to this.
Well, Doc, I agree with your position, because I think it was I want to get the name right, Priscilla, I believe.
Yeah, Selassie.
Now, yes. So yes, Priscilla. Okay. So like Doc said, the issues being raised goes just beyond this, and this isn't one that, like Doc, this medium will not satisfy the hunger that is embedded in the way she has put out the consent. So like Doc advised, find time, consult, and then then when everybody is seized with the full fact, some proper advice can be given to you. Otherwise, we don't want to give you rat poison.
So Priscilla should contact Stephen. Since I have stopped doing labor cases, please contact Stephen. Some small envelope like that. Stephen will give you the right way to go.
Doc, where are you going? Don't leave us. We still need you.
Oh, no. I'm done. I'm done with labor and HR issues. I now run the Institute of Leadership and Strategy, and my focus is on,
Doc. Congrats, Doc.
Thank you. Leadership and Strategy. So, Priscilla, please do contact Stephen, and trust me, he's a good resource and consultant. He worked for lots of organizations. I'm sure he would help you out. Forget about the money bits. Maybe just some little appreciation for him, and he will take you through the issues. But to advise you through this medium, trust me, you might be misled. Right.
Okay, thank you very much for that. And just to add up, you should also be considering getting your certified, because you'll be in good company of people like Stephen and other experienced HR practitioners. So speak to Stephen. Stephen, I'm sure by the time we'll be wrapping up, you want to share your number, right? Just when we're about to wrap up, I'll give you the opportunity to do that. Okay, let me take this from...
Okay, we'll be doing that.
Okay. Let me take this from Lily. Lily is asking, my employer usually gives me work to do on weekends because it mostly comes impromptu. For the weekdays, I mostly work 3 or 4 days instead of 5. Am I entitled to overtime pay for the weekend works while I don't work full work day? Okay, while I don't work full weekday. All right, Stephen.
Okay. Let's see. So Lily wants to know, she says she gets work done weekends. So for the weekdays, 3 or 4 days instead of 5. Okay, so Lily, this is it. Now, in every given week, you're supposed to do 40 hours in a week. Now, if you're doing 3 out of 5 days, then it means that in every given working week, you are not meeting your minimum, your 40-hour work for 1 week, because every day is literally 8 days of work. So what this would mean is that what your employer has done is that for the periods that you are not serving all throughout the week, as in Monday to Friday, those 2 days or an extra day of not working is made up for the time that you spend during the weekend to work. So I don't want to try to go into the mind of your employer. For a moment, I was thinking that he's employed you or she's employed you as if you are running a shift system. So you work for some days, you get some days off, and then you work to make up for it. And that is why you would find that even on the weekends, the employer will say, okay, let's get this work done. But during the week, you are giving time away from work to rest or take those days off. So if it is to help you meet the 40-hour-a-week schedule, then your employer is not doing anything wrong. But if you sit down and you do an assessment and you see, or you can identify that you are doing more than a 40-hour-a-week, then you should probably make time and sit with your employer and discuss and see if you can find a fair balance. And if there is some measure that can be made to reward for those extra hours, why not? Because if you're doing a little more than if you're doing 40-hour plus, then by the provisions of the law, you are entitled to some overtime pay. So Lily, let's look at the number of hours. Let's look at find a balance. And then once we are through with that, we can make progress from that point on. Governor.
All right, thank you very much. Let's take this from Marian. She's asking, considering permitted or prohibited deductions, is it right to deduct from an employee's salary when he has, for gender equality, when he or she has been absent for days or weeks without permission? Stephen.
I think let me take this one.
Okay, Dr. Bassi.
Right. Right. So at no time are you allowed to make deduction from an employee's pay. You want to read section 69 of the Labor Act. Section 69 is titled Prohibition on or Prohibited Deductions. And it continues to say that you shall not impose a pecuniary sanction. In law, pecuniary sanction simply means punishment involving money. So you shall not impose a pecuniary sanction for whatsoever the reason. The law says this, for whatsoever the reason, except for reasons stated in section 70. 70 does not include when an employee fails to come to work or when an employee is late. You, however, can deduct if the employee is a daily casual or a daily wage earner, a casual worker who earns daily wages. But if it's a salaried worker, if the employee is absent from work, well, look for punishment for the employee, but pay him his salary. You can't touch the salary. So somebody said, but that is cheating. If the employee is not working, why should we pay you? That is why you need to activate what we call, what is the name? Like when you are absent for a long time, can somebody help me? The policy. You must have a policy on vacation of posts. Vacation of posts. So what does your vacation of posts say? If you do not come to work for 5 consecutive days, when it comes to vacation of posts, the emphasis should be on consecutive working days. So if you don't come to work for 5 consecutive working days without permission, you will be terminated, blah, 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 blah. So punish the employee. So an employee doesn't come to work for 3 consecutive days without permission. Maybe it's not up to the 5 days you have in your vacation of post. So you warn the employee. The employee does it again. You give him a written reprimand and a threat of termination. He does it again. You either suspend before you terminate or you terminate altogether. That is what we call progressive discipline. And you can punish employees progressively, all right? And so it is about punish the employee, but don't touch his money. The law is against it. Their salaries are well protected by the law. So an employee is late. Some of you deduct 50 cedis from the employee's pay. They don't sue you, so you think you are doing the right thing. But if an employee should walk to the National Labor Commission, trust me, Stephen and his colleagues will make sure you'll be hot. You cannot deduct from an employee's pay. Their salaries are protected. I give a caveat, an exception. If the employee is a daily wage earner, so he hasn't worked for a day, he doesn't earn. But if it's a salary earner, at the end of the salary, you can't calculate the number of days he hasn't worked and deduct from the salary. No, you pay him his full salary and punish him for the days he hasn't worked. Right.
Right. Thank you very much, Dr. Bassey. So, ladies and gentlemen, on the 15th of December 2023, the HR Certification Center will be having the HR Professional Summit and Awards. The theme is Elevate HR, Bridging the Future. And it will be at Fiesta Royale Hotel. And it's going to be a day of keynote speeches and speaking panel discussions on very pertinent HR issues that have affected us in 2023 and moving forward are going to have a very huge impact on us in 2024 and even into the future. So the theme is Elevate HR, Bridging the Future. In-person goes for 550 cedis and online for 350 cedis. We also have available corporate packages. If you want to be part of this, kindly call or WhatsApp us on 020-800-7585. I'll take the number again, 020-800-7585. So the HR Professional Summit and Awards. You can also visit our website, phrglobal.com. That's www.phrglobal.com to nominate your HR practitioners or your business or your employer for some of the awards that we have listed for the summit. So please do well to be part of this, do well to share with your friends and colleagues, and let's all come getting close to the end of the year to celebrate milestones that our companies and we ourselves have chalked through the year 2023. All right, so thank you very much for your attention. We've come to the end of our discussion on the labor laws of Ghana. I must say that today we've had a bit of a change in, we've had very interesting questions. Thank you very much for spending your evening with us. Thank you very much for contributing. And as we round off, I would like to say a very big thank you to our sponsors, the HR Certification Center, for doing this with us. And if you are an HR practitioner or a business leader seeking to gain knowledge to elevate your practice in today's workspace, you should be thinking of the International HR Professional Certification. So you can call us on 0244 122 855 to enroll for our next cohort, which is actually the 37th cohort, taking off on the 2nd of December 2023. So before we round off, I want to take parting messages from our panelists. I will start with Stephen. And Stephen, when you are done with your message, kindly put out your number for anyone who wants to consult you or speak to you on labor issues. So you have the floor, Steve.
Okay. Thank you, Kwabena, and thank you, Dr. Bassi. And like I said earlier, I would always say a big thank you to the HR Certification Center, because these forums that you periodically provide is a way of bringing, regulators plus our clients together to be able to, share ideas, because I've also learned a few, if not so much, from what has gone on in the last hour and a half. And I must say thank you to the center. Now, what I would also entreat us, for those of us who are contemplating if I should get certified or not, I think that this should give us reason to answer that question that, yes, I should get certified. And if you want to get certified, I'm not sure that you should look beyond the HR Certification Center. Now, I've had fun. I've had a chance to learn a few new things from the questions that have been put across. Unfortunately, as always, the timelines are so much that the questions become so much before you realize 1 hour and a half is gone. Now that Doc is saying that he's leaving the labor front, I'll plead with him and the center if we can have like one special day, maybe dedicate like 6 hours of our time to take questions, offer suggestions, offer policy guidance for all participants. I think a 6-hour thing should, Kwabena, maybe we should look at, but that would mean that as for that particular day, Doc will not have any further engagement. I will squeeze in the time so that because I see there are still some questions in the chat box that we were not able to resolve, and it worries me a bit. But then again, I know the HR atmosphere, everybody has issues. I have issues as well. But like I said, I've enjoyed the discussions, and I'm sure that we'll do this again. And for those of us who didn't have our questions answered, or for those of us who were contemplating, should I ask or not ask, note the question down at the next session, and be quick to type yours first so that we would look at it and offer some advice accordingly. Thank you so much.
Thank you very much, Stephen. You forgot to add your number.
Okay, let me type it in the chat box.
Right. Okay, that's fine.
Okay.
Yeah, so Steve, yeah, we'll certainly look at having another session. Normally we have this once every quarter, but I think we are probably going to repeat this for this quarter, but we'll discuss and we'll let our cherished audience know what will be the next step.
Thank
you.
Okay,
Dr. Bassi.
Well, let me say thank you to you, Kwabena, and the HR Certification Center for inviting me. Kwabena have been teasing me that I am no more with the HR Center, and so they have left my matter for me, but he will still go around and come and invite me. So let me say thank you for inviting me to share my thoughts with you. Guys, I want to say thank you to you all for joining us. And all I can leave with you is that HR has become a technical area. It's a heavily legally regulated profession now. If you really want to be taken serious as a professional, get certified, gain mastery over your labor regulation, so you avoid driving your organization into avoidable liabilities. The days where I read psychology in school, I read theology. Oh, I'm a nice person. I like people, so I can do HR is gone. If you joke, you'll be dragged to the National Labor Commission. You'll be sent to the court. Your company will pay a lot of damages because you do not have grips on the technical issues. Even with an MBA, first degree, whatever, seek to be professionally certified. The degrees only give you theoretical grounding. The professional charters, some of the time, delve more into the issues than just academic certificate. So if you really want to be taken serious in the HR world, even managers who manage people, there are too many legal and technical parts of managing people. So please take the steps to certify. Like Kobina announced the numbers, just reach out to 0244-122-855. They'll take you through the process. Then you can do your certification, write the exam pass, and then you gain your confidence out there. Thank you all for your audience and for joining us this evening.
Right. Thank you to Dr. Bassey, and thank you, Stephen. And of course, Dr. Bassey will certainly keep coming to you. All right. So, ladies and gentlemen, thank you for spending your evening with us. We are very grateful. We appreciate sharing your precious time with us. Do have a great evening. And for some of us, our weekend is starting today. So we'll be enjoying our weekend. And for you out there who'll be starting tomorrow, nice weekend in advance. Goodbye and good night. Bye for now.